Today's session was about the changes in patent law in the United States. It's been interesting that over the careers of the three speakers, we've seen patents go from being very unimportant to being important and now moving back in the other direction, because that's what happens is they have things go back and forth like a pendulum, which is what you will see in any other area of life. So up until around the early 80s, patents were not very important. Then from the next 20 years, they became relatively important. And now there's a tax on them because of things that happened. But it's difficult because there are people who are trying to enforce patents when they probably shouldn't be enforced, and you have to have ways to control that. And also, you have situations where there are patents that are very important that are now being attacked, and they don't have good ways to take care of them. So what we were talking about there is how the things have developed over time, and then I said a few words at the end just about the new procedures for attacking patents in the Patent Office, what's happening and what changes we see might occur from here on.
Most importantly, though, in the United States Constitution, which sets up these three branches, we also have a provision that deals specifically with patents. And the Congress, as it says, shall have the power to promote progress of science and the useful arts by securing for limited periods, to inventors the exclusive right to their discoveries. So from this very important passage, we see all of the activity that has resulted in this pendulum swing back and forth over the past 60 years, which I'll be talking about. Pendulum swing, that going back and forth over the past 60 years in patent rights protection, how it started off very slowly anti-patent and then became very pro-patent, and now tending to be more anti-patent in the United States. But there's some very significant developments that are taking place globally. There's harmonization discussions that will level the playing field for all countries in the world. We're having discussions about having the same grace period, having the same prior user rights. This will be extremely important in making sure that both the patentee as well as the public understands what the patent rights are. There's also a movement towards having harmonization with regard to enforcement of the patents, so that the procedures that are used for making sure that you have the same protection in different countries, that is basically the same level playing field, is extremely important, because once you have rights, you know you can enforce them anywhere in the world, and that'll mean that there'll be less litigation because people will know that their rights are enforceable everywhere, not just simply country by country. So I think notwithstanding these swings back and forth, we really have a very optimistic view going forward that the patent rights, that the IP protection for all holders of patent rights and for the public will be predictable and enforceable.
I'm going to talk about three specific areas that have presented issues currently that are problematic for U.S. applicants for patents, and also some that are, I think, projected areas for the Supreme Court may be considering in the future. My talk was about three particular areas of U.S. law that are now problematic in some sense. So one of them was the patentable subject matter issue in the United States, where our Supreme Court has basically made it very difficult to define what is patentable subject matter. In the Alice case, which I talked about, they found the invention in those claims to be an abstract idea. And now the question for us attorneys is, how do we write a claim to something which is not an abstract idea? And that's not so easy. The Patent Office has tried to help us with some guidelines, but those guidelines are not that helpful. So that was one of the areas where we think the U.S. law will have to be changed by legislation in the future. Legislation in the U.S. takes a long time, 4 or 5 years at the best. So a number of organizations now are working on new legislation drafts which could be used to correct this situation. I also spent some time talking about standard essential patents, which is a growing area of dispute in not just the US but other countries. And finally, I talked about something called patent exhaustion. Patent exhaustion occurs when the first sale of the patented article is made, then the buyer is then free to use that for any purpose because the patent right has been exhausted, so to speak. And the issue now is whether or not that first sale can take place outside the United States and exhaust the U.S. patent right. And we have some cases that are pending that may answer that question. And it's going to be a very interesting situation to see how that question gets answered in the future.